Just want to introduce Archie Rabinowitz. I'm sure almost everyone here knows Archie. He's a partner at Gowlings and one of the go-to people in our business for estate litigation. And he's recognized as a leading lawyer in almost every directory. And so we're pleased to have him, and he is going to introduce his panel.
Thank you for that introduction. I'm not sure who it was for, but I'll take it while I get it. So just before we get started, I've got the honor and privilege of introducing three speakers today. We're going to be focusing on all of the exciting ethical questions that arise from our fact scenario. And all three, we're going to bring three different perspectives on how we deal with conflicts of interest. And one of the more exciting issues is how we deal with acting for an 18-year-old who may not be savvy enough or smart enough to know that his interests may be compromised. So I'm going to just introduce Michael Cadesky, who's our first speaker to my immediate right. Michael is well known, I think, to many of you. Not only is he managing partner of his own firm, but one of the leading go-to people when it comes to coming up with a creative solution on a complicated tax and corporate restructuring. Michael is, he is going to focus on, from the accountant's world, the rules of professional conduct that govern accountants and also the ethics involved in the issues that are triggered when acting for all three parties. Followed after Michael's talk will be Elena Hoffstein. Elena, of course, is well known as a leading estate planner and tax guru at Faskins. Elena is going to focus on the perspective from the legal profession. And again, similar issues, but different rules and different triggering points that affect the legal profession when acting for multiple parties who have perhaps different interests. And last but not least, my favorite rabbi, Rabbi Mordechai Torczyner, is going to now wrap it up by addressing from the Jewish perspective the halachic issues that arise in our fact situation, and also what our rabbinic advisors would talk about the morality when we have Brad having the audacity of taking a run at his parents. So with no further ado, I'm going to ask Michael to get started, and if there's any questions after or during his presentation, we'll take them. Thank you, Michael.
Well, thank you very much, Archie. You'll be relieved to know that you don't actually have to look at me for 12 minutes. I actually have a PowerPoint presentation, which is very typical of accountants. We can't live without them. So if I could have the first slide. And I'm also relieved to see that the room is almost completely full still. So you've obviously got a great deal of staying power. I was actually thinking of leaving myself, but then I remembered that I had a talk to do. So thank you very much for your attention. So the rules of professional conduct that govern accountants are applied provincially, province by province. The one that I'm familiar with, of course, is Ontario, but the rules don't vary very much across the country. The Ontario rules go on for about 190 pages. It seems that CPAs need an awful lot of very explicit guidance as to how they're supposed to behave. So I will be probably 2 to 3 hours covering the rules. Elena will be a bit briefer, and of course Rabbi Torczyner, his study of ethics will require an entire lifetime to master, but I'm heard that he actually does put on study classes. So the framework for accountants consists of 5 basic guiding principles. The first one is professional behavior, and that involves maintaining the good reputation of the profession and serving the public interest first and foremost over your own self-interest. The second principle is to act with integrity and due care, which means being straightforward, honest, fair, acting diligently, and where staff and associates are working on a file, making sure that the staff and associates are adequately trained and supervised. Number 3 is objectivity, making sure that professional and business judgment is not compromised by a bias, a conflict of interest, or the undue influence of others. Number 4 is to maintain adequate and appropriate professional competence, so making sure that the professional skills and competence that you bring to your work are suitable and up to date and allow you to perform the work at an appropriate level of care and correctness. And number 5, confidentiality, to maintain the confidentiality of your client's affairs and not to benefit yourself from that confidential information or allow others to benefit from it. And I think it will be quite evident if you cast your mind back to the case study that many of these points that I've just summarized come out very clearly in various aspects, particularly professional competence, confidentiality, integrity, objectivity, and so forth. Now, in looking at the question of trusts and CPAs, what I think is an important starting point is to look at the kinds of things that CPAs do. What do CPAs do when it comes to trusts? And I'm basically in this going to cover just inter vivos trusts, not testamentary trusts, wills, and estates. So the first thing an accountant might do is recommend a trust for tax planning, estate planning, asset protection, family law matters or concerns, probate issues, and potentially other purposes. So the CPA has identified a possible need within a client family, and will ask or introduce the idea of a trust to fulfill that need. The second thing the CPA may do is become involved in the design of the trust. Of course, we're not talking about drafting the trust, but developing a basic design for the trust. Who is the settlor? Who is the trustee? Who are the beneficiaries? What are the terms? Is it discretionary, not discretionary? What will go into the trust, et cetera, et cetera. And in the course of doing that, the CPA may review the trust deed and may also explain the arrangement at some level of detail to the client or the family. The next thing that the CPA will very typically do is accounting, tax return preparation, and what I would call routine tax planning advice, such as the allocation of income to beneficiaries each year, who gets what, how much, what is the nature of the income, and so on and so forth. Next on the list, investment advice, advising on the investments that the trust will make, looking at risk profiles, risk return, and generally helping the trustees and the client in their day-to-day investment decisions. The CPA may advise on distributions, such as what is appropriate to distribute to who and when, and what are the tax implications of doing it, and may provide valuation services to value companies, privately held assets, for purposes of determining distributions. And then, lastly, the CPA may become involved with the trust itself, either as a trustee or as an advisor. And based on what Jeff Berliner said earlier, I'm told that some accountants actually sometimes act as settler. It's disappointing, though, to act as settler and not actually be a beneficiary. If I was the settler, I'd also like to be considered as a beneficiary. So generally, I don't settle trusts for clients. But you may act as a CPA, you may act as a trustee, an advisor to the trustees, or an advisor potentially to the beneficiaries. Now, looking out at the audience and noting that many of you are involved in litigation, and we've actually heard several hours of presentations about litigation, I'm sure that what's of interest to you is not what do CPAs do, but what do CPAs do wrong. So I'd like to approach this in a hypothetical way, because of course I'm bound by the rules of professional conduct not to bring disrepute to the profession. So it's purely theoretical that an accountant might conceivably do something wrong, not suggesting it ever happens in practice. But in theory, the first common issue that we see is the CPA having the required level of skill and competence in order to advise on the broad area of trusts. Sometimes the CPA has a very limited knowledge. We'll look at a trust as being like a corporation, more so than like a trust. Doesn't really understand issues about income versus capital, beneficiaries, and so on and so forth. And there's a spectrum that I think those of you who can see the slides will appreciate, and it shows the level of knowledge. And on the one end is a very low level of knowledge, and on the other end is a very high level of knowledge of the CPA. Of course, relatively speaking, because we are CPAs, not lawyers. And if the CPA is at the low end, then you wonder if they're qualified to give the kind of advice that they're giving. And if they're at the high end, you wonder if they have a temptation or a tendency potentially to be giving legal advice to their client. If they go too far along the line of being or thinking that they're an expert, do they creep potentially into the legal realm? So it's important to stay within the sweet spot, of course, in the middle. The next issue is a very simple one, but a very profound one, and that is, who is your client? So usually that's answered quite simply by, it's the person who you send the bill to, and for the avoidance of doubt, it's actually the person who pays it, which might in fact be the same person sometimes. But when it comes to trusts, it's actually quite a difficult environment that you work within. If you're doing financial statements for a corporation, the corporation is your client. If you're doing tax planning for the shareholders and the family, they are your client, right? So the relationships tend to be fairly clear. But when it comes to a trust, is your client the settlor? Is your client the trustees? Is your client the trust itself? Or is your client the beneficiary? And if your client is the beneficiary, is it one beneficiary, all of them, the income beneficiaries, the capital beneficiaries? What difference does it make, or does it make a difference? So when you start mapping out the relationships with a trust, it becomes actually quite difficult to understand who in fact is your client. Many CPAs will think that the settlor is the client. Well, that may be the case when the trust is initiated, but after that, typically the settlor doesn't have an ongoing role unless there are reserve powers built into the trust. So why on earth would the settlor continue to be the client, right? It doesn't seem to make much sense, except that is probably the go-to person that the CPA goes back to. So the third issue, conflicts of interest, follows on to some extent from the second one. All of you will be familiar with issues of income versus capital, beneficiaries, favoritism to certain beneficiaries at the expense of others, potential conflicts of interest between the trustees, the trust, the settlor, and various other issues that can arise concerning the trust. So identifying the client is very important at the beginning, because how on earth do you avoid conflicts of interest if you can't identify who the client is? And if you're basically acting for everybody, well, that's fine while everybody's happy and the sun is shining, but as soon as it gets into nasty weather and people start lawyering up and so on and so forth, trying to figure out who you were advising and what were the terms of the engagement start to become very difficult for the CPA. The next issue is disclosure. Who has the right to information and what information should be provided? Very often, the settlor is given the information, but the settlor may have no right to the information under the trust. And if the CPA just gives the information to the settlor without having authorization from the trustees, arguably they're breaching a duty of confidentiality, perhaps without knowing or meaning to. Issue number 5, as a CPA, we loosely call this sham, but you could call it void, you could call it whatever really you want to call it, a bad thing. But sometimes we find that trusts are regarded as tax planning tools that are useful for achieving a particular purpose, and that's really all they do. They're not looked at as being legal relationships and arrangements. They're looked at as being something that saves tax, where you fill out a form every year and you allocate income in the most effective way and you save tax. And that's okay till somebody comes along and has a look at what you're doing. And that somebody could be the tax department, the beneficiaries, anybody who is concerned about the issues of the trust. And then it doesn't look very good. So ignoring the terms of the trust, obviously a very, very important no-no. Making payments to various people, particularly who are not beneficiaries, without approval. Lack of documentation, no trustee minutes, no bank account for the trust, none of the normal formalities of a business relationship, a professional relationship established for the trust. And the worst is what I call round-robin trips, where you allocate income to a whole bunch of different beneficiaries and they give you the after-tax amount back again, which obviously looks like and causes the trust terms to be completely disrespected. It starts to look very much like a sham. I'm told that CRA now have a questionnaire that is specifically targeted at round-robin trips. And then the last point that I'm going to address very quickly to stay within my time is the CPA acting as trustee. And if the CPA acts as trustee, then that takes all of the other issues that have been identified in 1, 2, 3, 4, and 5 and just puts them potentially on steroids because of the conflict of interest issues that can arise, because the CPA is involved in the decision-making, because if the trust is run like a quasi-sham trust, then the CPA is obviously part of it, being the trustee. It makes everything more confusing as to who is the client, because it introduces double dealings and so on and so on and so on. So on that happy note, I hope that has given you at least a quick introduction to the ethical framework for the CPA and my thoughts on how it applies on a common day-to-day basis with inter vivos trusts. Thank you.
I wonder if I could just ask a question just before we thank Michael, and I'll ask my panel members to weigh in on any questions that I may ask Michael, but you were referring to a discretionary trust and where there are situations where you might advise a trustee to allocate income as between different individuals, and where those individuals aren't necessarily the CPA's client. I'm wondering if there's anything that ethically obliges the CPA to give advice to the recipients of the distribution as to their responsibility to report and remit tax on that.
Well, that's a very good question. I think the first thing you have to do in advising the trustees on distributions is listen to what the trustees are mindful to do from a dollars and cents or financial point of view, because the funds belong to the beneficiaries, and if that's not appropriate to distribute in a particular way and so on, then they shouldn't do it, regardless of what the tax consequences are. But then I think that it is prudent practice to make sure that the beneficiaries have some understanding as to the taxation that they will encounter. When it comes to the U.S., as many of you know, the U.S. have these rules for undistributed net income, UNI, and a capital distribution to a U.S. beneficiary can in fact be taxable. And a lot of people are very surprised about that. If you happen to live in France and you receive a distribution from a trust, I think it's a mandatory jail term if you didn't report that you were a beneficiary of the trust, or if it's not, it's at least a plea bargain or something close to that. So different countries have all kinds of rules, sometimes favorable and sometimes unfavorable on distributions. And on the Canadian side, I don't know how you can make an appropriate allocation that is tax-driven without understanding the tax position of the beneficiary. So often it involves corresponding with the beneficiaries' advisors, other CPAs, lawyers, people who are knowledgeable. Does that answer your question?
It does, and I think Elena's got something to add as well.
Just, there are going to be new trust reporting requirements starting in 2021, where the trustees are going to be required to disclose to the CRA the names and SIN numbers and all sorts of other information about beneficiaries, and so that raises the bar with respect to disclosure requirements, and the fact that beneficiaries who might be living in France and not disclosing might have a bit of an issue, and it's part of the worldwide disclosure impetus and actions of various countries around the world. So we're being caught up in that net. It's important to know. I also want to say that it's very surprising to people who are entering into marriages and going to do marriage contracts that they are beneficiaries of trust, and they should report that in the financial disclosure documents of marriage contracts, and sometimes the settlor who's put in the multi-millions of dollars is saying, I don't want to disclose that. My grandson doesn't even know what he has. And I'm going, okay, well, then the paper's not worth what it's written on. So again, that raises issues in that context. So disclosure is becoming much more significant as we head into these types of situations.
If I can add, that is the worst situation that I typically encounter, and I just basically will refuse to act. It's the situation where you've got adult beneficiaries and you have an overarching parent or grandparent who doesn't want the children to know what they have, but does want them to report the income for tax purposes. And so you have somebody who actually does the tax return for them as well. I don't even know how they get it signed, or they just say sign here or something, or you just sign the e-file receipt. And it's all done for tax purposes, but the beneficiary doesn't even know that there is a trust. I mean, that is just, these days, just walking into a huge problem with CRA. I've seen a questionnaire that had questions actually directed at that. So I really would advise people not to go anywhere near that.
And then the child asks for the money later on, and then the rabbi is going to tell us why that's no good.
And then raising other potential ethical obligations about once the child makes the request or demand for the money, and there hasn't been full disclosure made. Yes. But we can touch on that perhaps. Let's segue into Elena's talk and some further questions that'll arise. So Elena, why don't you take it away?
Thank you. Not surprisingly, a lot of the themes that Michael has raised are filtered through on the legal side as well. The themes are common. The professional obligations, the ethical obligations are very similar, although they may be articulated in a different way. I don't have the prop that Michael had, but if I asked to do this again, I'll bring my props, because I always rely on that too, so good for you. It's not uncommon in the area of estate planning for the lawyer to slip into becoming the family lawyer and the acting for various members of the family as the years go on. They may start off as acting for the parents, but then the parents bring the children in to do their wills or marriage contracts, then they get involved in estate freezes or whatever, so suddenly they're starting to act for various members of the family. Then they're also acting for the business, maybe the business partner, and other relatives. So you can see how a lawyer could easily fall into the type of trap that I'm going to be talking about, dealing with conflicts of interest. How often had we have a child coming to the lawyer saying, well, my parents are getting elderly, but I'd like to give you the will's instructions, and by the way, they want to leave everything to me, and not to my ungrateful siblings. So of course you have to double check that. Or a spouse comes in and says, well, my spouse isn't really knowledgeable in financial matters, and I'm going to tell you what my spouse wants with respect to a will. So again, these things can creep up on you, and it's easy to slip into the conflicts of interest situations. The number of claims, malpractice claims that have arisen over the years, a lot of them relate to conflict of interest situations. So it's important to be alert. And not only to be alert to potential conflicts of interest, but also to understand how to handle and to avoid liability. And you want to ensure having a good relationship with your client, and part of that is to demonstrate loyalty and be in a position to provide objective advice. And the most important question to ask for a lawyer, and Michael addressed this from a CPA's perspective, is who is the client? 3 people walked into Novice's office, and they were the parents and Brad. And, we have assumed in some cases that it was Brad who was the client, but I don't know. Maybe it was the parents. Maybe the parents brought Brad in. Maybe Brad agreed to be brought in. So that's the fundamental question. Who is the client? And it's important to identify that client, as Michael has pointed out. So the important rule in this area, and the one I've been asked to address, is Rule 3.4 in the Rules of Professional Conduct. And just like the CPA's manual, each province has its own rules of professional conduct, but not surprisingly, they're very similar. So in Ontario, it's Rule 3.4. It's one of the longest rules in the book, and that and the commentary are fundamental to the way in which we're supposed to practice law. And what it says, what that rule starts off by saying is that there's a duty to avoid a conflict of interest. It also talks about joint retainers, and I'll be mentioning that briefly, but if you look at the fact situation that we had, basically there is absolutely no doubt that no vice didn't even read 3.4, Rule 3.4, or if she read it, she had no idea what it meant. She didn't recognize the potential for conflicts, didn't do anything about them, didn't get informed consent. There was no disclosure. There was no retainer agreement from what I could tell. I know the facts are left deliberately vague so we can talk about them. But so if she hasn't been sanctioned by the Law Society, she stands a good chance of being sanctioned based on the behavior that occurred at these meetings and the advice that was given. So one of the first questions that is asked and answered is, what is a conflict of interest? And there is a definition of the conflict of interest in the rules, and is defined as follows. It means the existence of a substantial risk that a lawyer's loyalty to or representation of a client would be materially and adversely affected by the client's own interest, by the lawyer's own interest, or the lawyer's duties to another client, a former client, or a third party. The risk must be more than a mere possibility. There must be a genuine, serious risk to the duty of loyalty or to client representation arising from the retainer. So it's very clear that there was a real risk to the most important person in this scenario, which was Brad, that any advice that was given to Brad, there was a conflict of interest in dealing with it. At the heart of the solicitor-client relationship is a fiduciary obligation not to do harm, and the rule exists as a result of the duties that relate to the fiduciary obligation. And these duties are set out in the rules of professional conduct and included in them. Now, I'm not going to list them all, but fundamentally there's a duty of loyalty, and that loyalty has a subset of confidentiality, candor, and commitment to the client. So the lawyer needs to show judgment to be able to judge whether she has compromised her duty and breached her duty to the client, whoever that client is. And the onus is on the lawyer to assess each retainer for any such risk. It's not up to the client to say, I have to figure out whether you have a conflict of interest. It's up to the lawyer. 2 minutes. Oh my God, I'm going to speed this up. It's up to the lawyer to figure that out. So Brad, as part of our fact situation, we know that Brad said he was indifferent to the money, but there was no evidence that the lawyer was delved into that or explained to Brad what the risks were and should have. So there was an obligation to be vigilant, to talk about the tax issues, to explain to Brad that there were other ways of structuring the trust and the arrangement in a way that could have protected him. So he should have gotten better advice, and also ILA. The second, I'll just quickly run through the other 3 points I wanted to make. One of them is that there is an exception to the conflict of interest rules, and that is if the clients consent to the conflict and agree to go forward. Very often this arises in the husband and wife situation, but it could have arisen in this situation where if, for example, no vice thought that she was representing all of them, to get the consent of the various parties to the conflict and move forward and get the right advice in front of them, because they could have managed this conflict. Consent has to be fully informed and has to be voluntary. Therefore, no vice should have advised them what the risks were, what the conflict was, and gotten informed consent. She had a positive obligation to recommend ILA, and she didn't, but that's part of what informed consent is. So she failed to properly assess the conflict risk, she didn't inform the parties of the risk, and so she couldn't get the required consent. The third thing I wanted to mention was, with respect to joint retainers, that there are other steps that have to be taken when there is a joint retainer, that whenever there is a joint retainer, you have to agree or acknowledge that any information that is given by one client has to be disclosed to the others, so information has to be shared. They all have to agree to it, and if a conflict arises, then the lawyer can't act for any of the parties if a conflict arises later. And document. You need retainers. You need to document the advice that was given. and just keep those things in your file. The last thing that I had wanted to mention was that the ethical obligation to consider possible conflicts of interest not only arises when the client comes into the office, but it's an ongoing requirement. So that means that if, for example, you started off not having a conflict, but as the years go on, conflicts arise, you have to be aware of that possibility and address that possibility as well. So it's an ongoing ethical obligation. Thank you. Is that 2 minutes?
It was fine. I had a false reading on my watch, so you did not go over time. I was just going to ask one follow-up question, because we know in our fact pattern, Brad seemed indifferent, and you were talking about how lawyers and professionals can slip into the situation where it's vague, it's unclear who their client is and to whom they owe the obligations. Do you have any tips for our audience of what steps you might have taken in practice over the years if you ever came across a situation where one of the key individuals, namely Brad in our case, just didn't seem to be reacting in the way that one might have expected, with the benefit of hindsight?
I've had that come up in practice. It clearly comes up in the fact situation. He is a vulnerable client, and that means you have to be extra vigilant. And when I've had that situation come up, I have made sure that I've mentioned to the client many times what the potential risks are. And I've even tried to have other people present when I've given those instructions. I've also taken copious notes and put them in my file. That's called self-preservation, because I don't want the client to come back to me and say, you didn't tell me X, you didn't tell me Y. So I want to make sure that I've documented the advice that I've given, not only in the notes that I take during the meetings, hopefully with another person present, but also I send a letter to the client confirming the advice that I've given, and very often I get them to sign that letter acknowledging that that's the advice that was given. I've often taken the step of saying, and you need to get independent legal advice, because especially in a conflict situation, you want to make sure you're protected. And this is self-protection. It's not just the obligation you have to the client, but you want to protect yourself and make sure they're not going to come back to sue you, because very often they do. And it's very good to have that kind of documentation in your files to confirm that you gave that advice several times.
Thank you. Rabbi, can you shed light on this and help us out from your perspective and our perspective?
I can try. And the last speaker on the last panel, kudos to everybody who stayed. For me, the challenge was different. I had to disappear in the middle to go out and hold 2 Jewish Jeopardy sessions with middle school students who were very enthusiastic, very energetic, and very loud. So I would have actually liked to stay, but in any case, thank you very much for inviting me. And Michael and Elena, I enjoyed reading your papers on the topic. I wanted to talk about 3 particular points. Number 1, the issue of who is the client. So we've heard a lot about the professional obligation. From a Jewish law and Jewish ethics standpoint, there's an additional layer, which is who thinks they're the client. Meaning it's not only a question of who's writing the check or the question of who really has a claim on me professionally, but from a Jewish ethics perspective, we are required not to mislead anybody. And so if I'm in a situation in which someone does not hold the role as client, but they think they do, I have a duty to make sure that they understand their role and my relationship with them, to make sure that they're not operating under the assumption that my advice is actually for them. Which exists, it's not only a Jewish ethics concept, it exists also within the Law Society's ethical rules, but I'm speaking from the Jewish perspective. So that's number 1, the duty to make sure that everybody understands who has a claim on your advice. Second, in terms of conflict of interest, the Jewish ethical rules and protocols are pretty similar to what the Law Society sets out. Jewish law recognizes that a range of influences and interests can bias a professional. And it shows up in legal contexts, it shows up in terms of legal guardians, it shows up in terms of judges, witnesses. So the interests include the obvious, meaning financial interest. Family relationships can disqualify somebody from playing a role in a judicial proceeding in particular. Friendships can actually disqualify somebody, so that Jewish law, when it talks about who's qualified to serve as a judge on a Beit Din, on a rabbinical court, may disqualify potentially a sonei or an ohev, somebody who either has a strong dislike or strong positive relationship with a litigant. Even small favors can actually disqualify somebody as well. There's a great sensitivity to interest and conflict of interest. We have three concerns, Jewishly, about where a conflict of interest may lead. The most obvious is self-serving violation of duties, where there's a particular interest to go in one direction as opposed to another. But besides that, there is a concern for unconscious bias. The Hebrew word for an interest or a bribe is shochad. And the Talmud actually says to take the word shochad and read it as shehu chad, meaning that the bribe or the interest makes you, the recipient, into a joint party, a unified party with the person who gives it to you. It makes you see them as yourself and their interests as your own. And so that's a concern, is that unconsciously a person is biased. And then there's a third concern, which is undermining the public trust, where there's a perception of conflict of interest, but there's no actual conflict of interest. Jewish law is still concerned. And because of that, it requires the following steps. If the interests can be untangled and you can figure out what the interests are and where the conflict is, then there's a duty to clarify to whom one is loyal, who is the client, to actually identify the client, to notify the participants of how one plans to proceed, and to gain their consent, very similar to what's already been outlined, with two caveats. Number one, to recognize that where you can't untangle the mess, but in fact you have a situation in which there are multiple parties who have the claim as client and their interests are in fact in conflict, to walk away, to say I can't represent all the clients in this case. And then the second caveat is that where there are appearances of wrongdoing from a Jewish ethics standpoint, then consent doesn't help. So that the Shulchan Aruch, the Code of Jewish Law, discusses a case in which there's a legal guardian who wants to engage in a transaction with the money that he's responsible for, and there's an appearance of self-dealing in that arrangement, where even if there is a general agreement by all involved that this is okay and it's above board, nonetheless, Jewish law will say not to engage in it because of concern for the appearance of self-dealing. Last, the question of suing one's parents. So, at tab 17, you have a paper that I wrote on the topic, May a Jew Sue Her Parents? I might have expected Judaism to say no. You're not allowed to do that. We have a very heavy emphasis on honoring parents, recognizing them as partners with God in bringing life into the world. The Bible has no fewer than 4 separate obligations for children in terms of their responsibilities toward their parents. The Talmud has all sorts of very enlightening stories about how various sages honored their parents, rising when they stood up and they entered the room, and not responding when they were shamed by their parents in public. All sorts of very beautiful aspirational stories that might really want to say, no, you can't sue your parent. But actually you can. There are 3 different types of duties of parents to children in Jewish law. One are religious duties, meaning there are certain religious responsibilities that parents have towards a child. So, for a son to provide brit milah, circumcision, would be one of those responsibilities. However, a child cannot sue the parent for failing in that regard. The parent didn't give you a Jewish education. You can't sue for all that tuition money that they saved. That doesn't work. And the reason is because their religious duties are really their relationship with God. It's not about their relationship with the child, since the child cannot claim anything from the parent. They can be bitter, though. That's okay. The second realm of parental responsibility is in terms of financial harm. What if the parents did things that in fact undermined the child and damaged the child's finances? And here there's a Talmudic debate. When we say children are responsible to honor their parents, does that mean they have to spend their own money in order to do so? And the conclusion of that debate is that children are not responsible to spend their own money. You have to spend your parents' money to honor them, but you don't actually have to spend your own. And therefore, a child who feels that her parents, in fact, damaged her finances would be able to sue and recover what was lost. However, respectfully, it has to be done in a manner that's consistent with the respect required by Jewish law and only where there is no better option. And last, where a child provided support for parents. So we say that, I mentioned before that a child is not responsible to spend personal funds to support the parent. That's true under the law of honoring your parents. However, there's a separate obligation of tzedakah, of basic philanthropy. And for that we say family first. So that if you have somebody whose parents do not have the means to support themselves, the primary tzedakah responsibility of the child is to use their funds to support the parent. So 20, 30 seconds. Oh, that's more than I need. The responsibility of the child is, in fact, to spend their tzedakah dollars in order to support the parent. So if the child says, I supported the parent for X number of years, and then I find out that the parent actually had means, and did not need to receive this money as tzedakah, the child has a claim and, in fact, can sue to recover it. Whereas if the parent really didn't have the means to support themselves, then no, that was legitimate use of tzedakah, and even if they come into money afterwards, the child cannot claim that money back.
Well, thank you, Rabbi. That definitely raises got my head spinning in terms of some questions that unfortunately we don't have time for, but I want to thank all of our speakers, and I'm going to turn it over to Jordy. Thank you.
Thank you.